day, everyone. My name is Scott Reich, and this is Crime Talk. Welcome. This is the weekly recap of all the top stories throughout the week in one convenient location. So yes, please don't complain that you've seen this before. This is the weekly recap for those who don't have time to watch it all throughout the week. Top stories, one convenient location, right here. Thanks for watching. Hope you enjoy it. All right. Now, we knew this was going to happen. It was only a matter of when. But yes, meet this woman, Brittany Kohberger. Well, apparently she has written a series of Facebook posts professing her love for the accused murderer of the 4 college classmates. She is gushing that Coburger is the perfect man in her life. In one post, Kohberger said, "My love interest is named Brian and is accused of murder, and I just wish to connect with him above anyone else." She states in her post that one way to describe her feelings for him over the last week or so is kind of like being lovesick. Now, Kohberger started posting her passionate letters to Coburger on January 4th, just a few days after he had been arrested at his parents' home in Pennsylvania for the murders. The single Kentucky mom, who has a 16-year-old son, pointed out that she and Coburger shared some things in common, such as their astrological signs, both apparently Scorpios. She also claimed they've had similar birth charts, making Coburger her divine masculine counterpart. And Coburger has been charged, obviously, with the murders of Kayla Gonsalves, Madison Mogen, Zana Kernodle, and Ethan Chapin. He's denied any wrongdoing. The matter is set for a preliminary hearing on June 26. So, what does that mean? I don't know. I just do not get it. I understand it's a very low standard for dating these days, but when you're looking at spending the rest of your life in prison and possibly death, I just don't see how that would be a great match made in heaven. Maybe if you want a relationship where you never actually really have to get to know somebody, that's the perfect way to do that. That's just weird. I don't get it. I never understood it. I just don't get it. Makes no sense to me. We saw it in the Chris Watts case. Heck, we see it in every case whatsoever. All right. Next on the docket, can you believe this? Brian Kohberger maybe has some issues with women. That's right. You know, Brian Kohberger, the man charged with the slaying of 4 University of Idaho students, was reportedly fired from his job as a teaching assistant just days before his arrest. Now, as we've explained before, Mr. Kohberger was a doctoral candidate in criminology and a teaching assistant at the Washington State University at the Pullman campus. But apparently, Mr. Kohberger had received several warnings from the university in the months prior to his arrest and was officially terminated from his teaching assistant position on December 19th of 2022. A letter that was given to Mr. Kohberger before he was terminated stated that he had a sexist attitude towards women when he interacted with the students there at the university. And in fact, it was reported that he was rude to women and that he apparently graded women's papers much differently than the men. Now, this letter also reportedly detailed a timeline of events leading up to Kohberger's termination, beginning with an alleged altercation with the professor on September 23rd, just weeks into the job. The letter allegedly states that Coburger and the professor then met on October 3rd to discuss professional behavior. The professor then reportedly emailed Coburger on October 21st to tell them that he had failed to meet the expectations set out in the meeting earlier that month. They met again on November 12th to discuss an improvement plan, and another meeting was held on December 7th to discuss how that plan was going to be implemented. On December 9th, Coburger reportedly had a second altercation with the professor. He was terminated 10 days later. Interesting. 3 of the 4 victims were females. He has issues with women. Well, maybe it's just nothing at all. Next on the docket, there was a motions hearing in Lori Vallow and Chad Daybell's case. And it really makes you wonder, does anything ever really get resolved in Idaho? I'm not sure. Several items were on the docket, including a motion to sever the cases. There's some issues regarding Lori Vallow's mental health evidence And obviously the trial is scheduled to begin April 3rd. Lori Vallow, when she came into the courtroom, was wearing a white blouse and black dress pants and has a big smile on her face, apparently. Now, it's interesting. I understand dressing for trial, but I do not understand allowing a defendant to dress for pre-trial hearings. It just makes no sense. You're in custody. You wear the jail smock. It's that simple. Anyway, apparently Lori was getting along with her attorneys, which is good. We want to have a good relationship with the attorneys. And Chad entered the courtroom after she did. Now, first on the docket was a motion filed by Lori Vallow's attorneys to dismiss the case for lack of a speedy trial. Needless to say, the state objects to granting that continuance. Now, Jim Archibald argued the case on behalf of Lori Vallow, and Mr. Archibald argued that Lori Vallow's constitutional rights have been violated as she has not waived her right to a speedy trial, and the trial should have legally happened within 6 months from the date of arraignment. Why would he ask for such a thing? Oh, that's right. That's what the law says. That's right. Now, there is an exception for good cause. They can extend that in co-defendant cases. That law's there as well. But usually we're talking a couple of weeks, not months. Anyway, we digress. Anyway, Mr. Archibald argued that here we are with a trial set the defense knows is outside the speedy trial setting. The state knows that it's outside of the speedy trial setting, and the court knows as well. So what's the remedy, he asks? He says the Idaho legislature says the remedy is for the indictment to be dismissed. Mr. Archibald said that the statute is rather clear, and the speedy trial obligation is on the prosecution, not the judge, not the defendant, not the defense lawyers. The obligation to respect a speedy trial is the government, the prosecution. I've been saying that all along. They have a duty to protect the record. But instead of saying, we'll go try this case any place, anytime, anywhere, what has the prosecution done? Delay, delay, delay. Oh, we're not ready, Judge. We're not ready yet. Usually you hear that from the defense. Anyway, is the judge going to grant this? I would find it hard to believe that he would do that since he's the one that found good cause, and he's not going to say that he did it wrong. That's going to be left up to appellate courts if, in fact, there is a conviction. Now, the prosecutors argued on behalf of the state, saying that the court has already determined that good cause to continue or delay the trial outside of the 6-month statutory speedy trial is sufficient. The government said there were 44-day delay from the defense team that resulted in the vacating the January trial date. This was the time Lori Vallow's competency was in question. I agree. That time is told. Those 44 days don't count. But guess what? Once the clock starts ticking, it's on the prosecution to get them to trial. Anyway, the prosecution has asked Judge Boyce, obviously, to deny the request of Ms. Vallow, and Judge Boyce said that he'll issue a written decision soon with his ruling. Don't be surprised. It's not going to get dismissed. I would literally fall over right here in front of the CrimeTalk microphone and hit my head on the CrimeTalk desk if that, in fact, happened. Judges just don't admit that they're wrong. They just don't do it. Next was the Lori Vallow's attorneys asking the judge to allow individual voir dire examination when it comes to picking a jury in this case. And they want to be able to talk with jurors about issues such as religion, mental illness, and drug use. Now, prosecutor Rob Wood says state believes that small groups are good when it comes to voir dire, but is going to object to defense attorneys asking jurors about their religious affiliation and what congregation they belong to. Judge Boyce granted the motion in part, allowing the individual voir dire, but says that small groups will be used and then individual examination will be used for sensitive issues. That's really straightforward. You do the small groups, you qualify them. If somebody has something that they don't want to discuss in front of everybody, then you simply go in chambers. There's court that's taken down. Everything is taken down by a court reporter. That's normal. That happens all the time. Next was a motion to disclose the death penalty phase information. Needless to say, Lori Vallow's attorneys are asking the state to disclose any information in its possession or in possession of law enforcement which might be relevant or admissible in the penalty phase of the case. Seems obvious. Do you think they'd want to turn that over already? Rachel Smith responded for the state on behalf of this motion, says that they will rely on any evidence used in the guilt phase for the penalty phase of the proceedings, and they will offer any evidence, and we will supplement before the discovery deadline any endorsement of witnesses that they intend to call at the penalty phase. Prosecutor Smith says that they have a witness ready to testify about hyper-religiousness versus using religion as an excuse or reason to commit a crime. Lori Vallow Daybell was apparently taking notes throughout all these proceedings, and then Lori Vallow had a motion for the pre-selection instruction to potential jurors. Both the state and the defense agree that some instruction needs to be given to the potential jurors before the jury is picked, obviously, and each side has submitted their proposed suggested instructions. Judge Boyce grants the motion to have the pre-selection instructions given to potential jurors. Oh my goodness. Wow, we got something done there. He says he's working on what those instructions will be and will consider input from both the state and defense. So here's what it should be. The defendant is charged in an indictment with the death of her children, and Chad Daybell is also charged with the conspiracy for the death of his wife, Tammy Daybell. They're all charged in the same charges as a conspiracy. The defendants have entered a plea of not guilty, and if there is a conviction, the state will seek the death penalty. There it is. Done. They need any help? Just give me a call. Anyway, the state that had a motion to compel, basically saying that the defense hasn't turned over a witness list, and the defense says we'll comply with any and all lists and deadlines as they come due. Judge Boyce denied without prejudice a motion to compel after the defense says it's going to comply. Shocking. All right, we got something else done there as well. Lori Vallow's motions hearing then concluded, and then Chad Daybell's motions were set to begin after a short recess. Mr. Archibald indicated that Lori Vallow wanted to remain in the courtroom to see her beau. That's right. During Chad Daybell's portion of the case, Judge Boyce said that was fine. I mean, they are charged co-conspirators. Let them see. Why we're doing separate hearings, I don't know. Anyway, after Chad Daybell entered the courtroom, once again, he's wearing his white dress shirt and red tie. He briefly looked over at Lori, and they smiled at each other. Can you imagine? Little match made in heaven. Anyway, the first motion was Chad Daybell's motion to sever the case from his wife. John Pryor, Chad's attorney, says he has found issues with discovery and the cases should be severed. Needless to say, the prosecuting attorney objects and says that Mr. Pryor's arguing was not contained in his written motion to sever, and therefore they weren't prepared to go forward. So the motion to sever will now be continued until February 23rd so that both parties can adequately prepare and file additional documents. Really? The DA couldn't argue, even if it wasn't completely in the motion? She knew it was a motion to sever. Everything at issue in the case could be an issue to sever, and she wasn't prepared to argue it? Come on. Anyway, Mr. Pryor's motion to compel regarding DNA results was then filed. We talked about that last week. And he says, I do want the court to be aware that I did file a declaration with my DNA expert that we've read to you. And he said that once he gets the DNA results in 3 weeks, he'll need approximately 60 days. That would be past the date when the trial is scheduled to begin. The prosecution says that DNA results could be back by the next hearing, February 23rd, so they agree that the motion could be continued 2 weeks. And then there's the motion to compel will now be heard once again on February 23rd. Pryor argues that he needs more time to prepare for trial. The concern is that from December 25th until the present time, he has received 5 additional items of discovery, and he needs additional time for his experts. Mr. Pryor says that he was given GPS evidence from the state that was significant, and it has taken a significant amount of time for his expert to evaluate and issue a report. He does not expect to receive that report for at least another week. And Pryor then said that he was handed 1,100 pages of additional documents last Thursday afternoon that lays out additional witnesses that he may need to call. He states that even if he worked 24/7 in the next 3 to 4 days, he won't get through it all. And Mr. Daybell has not seen it at all, so he needs more time. Judge Boyce granted Mr. Pryor's motion to extend deadlines in regards to disclosure of discovery until March 13th. Original date was February 27th. And that was it. Really didn't get a whole lot done, did they? Except more extension and delay and delay. I just don't get it. All the judge has to do is say, hey, government, you've had this case for 3 years. You could have tested all this evidence over the last 3 years. Why did you wait? Here's a firm deadline. You don't get to use anything after this particular date, so there's no need for the defense to ask for a continuance. If your case is so overwhelming, you won't need this late-breaking discovery. We'll leave it at that. I just get so frustrated because this case is not really that complicated. They have turned it into a complete monstrosity, and it is going to be a complete cluster. You know what I mean, okay? And if I was the prosecutor, I wouldn't want it televised either because I think they're going to look like some bumbling fools. Just saying.